Hey, all persons having business with the appellate, please join here, give you attendance, and you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. We have 5.5 hours of requested argument time. So as I say to everyone, please ask for the time you actually need, not the time that you want, understanding that the court is fully familiar with the briefs, the facts of your case, the record, and if we have additional questions beyond the time that I have allotted you, I will permit my colleagues to continue asking questions. So if you're giving us excellent argument, it will continue, okay? People versus Jermaine Bryant. Submitted. Rodriguez versus Moss. No, just give us your time for argument. No. How much time would you like? It's okay, 5 minutes? Okay. And respond? 10 minutes? Okay. All right, so you're not listening. 4 and 1 and 5. Silanette versus Michelle R. Submitted. Hardwood versus RNF Limousine.
For appellant, 3 minutes, Your Honor.
Okay. Do you wish to argue? It seems you have, your opposition is not here. Do you wish to submit or do you still want time?
If Your Honors would be okay with just me taking 2 or 3 minutes to sum it up.
You got it.
Thank you so much.
I'll give you 2 minutes.
Thank you.
DS Infant versus New York City Housing Authority.
DS Infant, 3 minutes, Your Honor.
Do you want rebuttal time?
No, Your Honor.
Okay.
Appellant, 4 minutes and 2 minutes rebuttal.
Okay, oh, that's why I was confused. Okay. Okay, 4, 2, and 3. People versus Rosemary Hernandez.
Appellant requests 5 and 2.
Okay.
Respond to request 3, Your Honor.
5 and 2 and 3. Forrest Walnut versus Abziger. Okay. 4 and 2 and 5. Spolter versus Spolter.
Appellant, 12 and 3, Your Honor.
Okay. All right. 6 and 2 and 7. Diaz versus P&K Contracting.
Appellant, for P&K, 5 minutes.
Okay.
Cross appellant for plaintiff appellant Diaz, 5 and 3, please.
Okay.
Respond to TDX 3, please.
Okay.
And respondent Steele, 3 minutes, please.
All right. 5 and 1, 5 and 1, 3 and 3. Panasia Estate versus 29 West 19th condominium. Submitted. People versus Vicente Reynoso.
5 and 1, please, Your Honor.
Okay.
5 minutes, Your Honor.
5 and 1 and 5. Vitol Americas versus Targer Resources.
For appellant, 5 and 2, please, Your Honor.
Okay.
For respondent, 5.
5 and 2 and 5. Deutsche Bank versus Fresh. Submitted. Old Castle Precast versus Steiner is submitted. White versus Metropolitan Opera is submitted. First case on the calendar, Rodriguez versus Ross. Judge Rosado is recused on this case. Should there be a tie, this court will follow its rules with respect to that. You may be seated, and the first to argue can step up.
May it please the court, my name is Kathleen Beatty and I represent the plaintiff appellant Jennifer Rodriguez. This personal injury matter originates from a motor vehicle collision that occurred on August 3rd, 2014. Judge Barbado grants the defendant's motion made under the insurance law 5102D regarding the serious injury threshold, dismiss the case.
How did you oppose and create an issue of fact?
The opposition consisted of testimony from the plaintiff as well as affirmed records from the plaintiff's treating providers and the plaintiff expert, Dr. Koran. specifically with regard to the 90-180 category, that the plaintiff had sustained an impairment that prevented her from performing substantially all of material acts which constitute her usual and customary activities.
In light of the fact that she was only out a very brief period of time from work following the accident, and does not describe, as I recall, in her testimony, any significant limitations of her customary functions, how is that 90-180 even met?
She testified that she missed several days from work as a police dispatcher and 911 operator, and she needed accommodations to complete her work when she was there. She had to alternate between sitting and standing and taking medications. She also testified that she was limited in activities outside of work regarding her recreational and day-to-day activities like cleaning, grocery shopping, sitting, standing for more than an hour, bless you, driving for long periods of time, bending over and picking things up. Being that one of the injuries was Ms. Rodriguez's right hand, and she's right hand dominant, she was affected in more ways than just at her regular employment. Separate apart from the regular employment, there are some cases that talk about the qualification of activities outside of work as a breach of the threshold. There are two other categories as well that Ms. Rodriguez's injuries breach here: the significant limitation and permanent consequential limitation of range of motion categories.
But how is that, again, the plaintiff's own orthopedic tests were negative for any abnormalities, and it found that her sprains and strains had been resolved. And under our progeny of case law, sprains and strains never rise to the level of serious injury under 5102D.
There were MRIs that showed more than sprains and strains, and objective range of motion testing that showed more than sprains and strains that were more than transient in duration. There were MRIs that confirmed bulging discs at the levels of C5, C6.
But we know that even a bulging disc by itself, with nothing more, is insufficient. And can you tell me how the gap in treatment that was identified, a 7-year gap in treatment that was identified, was that even addressed by plaintiff's experts?
In addition to the bulging disc confirmed by MRI, there were also objective measurements of limitations of range of motion of 10 degrees, 10%, 25%, and more to the cervical spine and the lumbar spine, as well as the right shoulder. They were documented shortly after the date of the incident, as well as months later, continuing on for 8 months after the date of the incident. And there's some case law that says that the limitation of range of motion does not necessarily have to be permanent, as long as it's not very short in duration. If there's significant limitation for several months, that could qualify. With respect to the gap, there are explanations here because Ms. Rodriguez was pregnant.
Right, you're out of time, so give me a quick response, and if not, you can address it on your rebuttal.
Okay. About 8 months after Ms. Rodriguez had this incident and continuously treated, she became pregnant, and that was a good reason for her to stop receiving the medical treatment, because her doctor said that she could not, at that point, continue while she was.
Why? Women who are pregnant go to the gym. So why would getting physical therapy be a problem? I don't understand.
She chose in this instance not to have continued therapy while she was pregnant, and then she had an issue with her medical insurance that prevented her from continuing on because no-fault benefits were not covering her therapy.
All right, anything else you can address on rebuttal? All right?
Thank you.
Thank you. You may proceed.
Good afternoon. Good afternoon. May it please the court. My name is Jonathan Weinstein from the Office of Vute Lorfick, McAndrew, Meisner, and Roberts, here to represent defendant Martin Moss. I'll be brief. This is a very straightforward case. Ms. Rodriguez did not suffer a threshold injury under any category of 5012D. Nothing. None of the injuries are threshold. Yes, there are bulges, herniations, ranges of motion documented in the records, but none of those, none, qualify as a threshold injury without anything else. And there is nothing else. Everything else is either subjective or self-serving testimony at Ms. Rodriguez's deposition. The court correctly noted unaffirmed records in support of the opposition to the motion below. 4 experts supported in favor of the opposition below. 3 of whom directly examined Ms. Rodriguez herself. In opposition to the motion, appellant also submitted an 11th hour exam a mere 6 days before opposition by a Dr. Johar, who was silent, completely silent, as to the prior 7 years of her care. There's a clear gap in her treatment. Dr. Johar does not refer to anything that happened, cutting off any causation. Moreover, anything that he cites, again, does not qualify as a threshold injury. Respectfully, I'll see the remainder of my time. Thank you very much.
Thank you.
The last issue that I'd like to comment about, which is responsive to your last question about an unexplained gap, is that Dr. Johar examined the plaintiff years after the date of the incident and found that she had reached maximum medical improvement. So at a certain point, the treatments that Ms. Rodriguez was receiving were only palliative and not going to improve her symptoms. Because at a certain point, the treatment was not going to be improving her condition, there was no need for her to continue on receiving the therapy. She got to the best that she was going to be under the circumstances. And so there is no unexplained gap of several years, as opposing counsel stated. There are a number of reasons that the plaintiff discontinued her treatment. It's our position that based on the treating physician's records, which started the day after the incident, continued on for 8 months, and then Dr. Johar's report from April of 2022, that Ms. Rodriguez's injuries do qualify as serious under the 90-180 significant limitation and permanent consequential limitation of range of motion categories, and therefore the case should be reinstated. Thank you.
Thank you. Hardwood versus R&F Limousine.
Good afternoon, Your Honors, and may it please the Court. Ross Frisha of Michelle and Horn for the Plaintiff Appellant. It's our position that the motion court erred in granting defendant's motion for summary judgment for several reasons. First, defendant cannot meet its burden through its expert, Dr. Buckner, because defendant's expert did not compare his measurements of plaintiff's range of motion to a set standard normal ranges of motion. And the defendant does not cite a single case where the First Department held that it was not necessary for an expert to compare its measurements of the range of motion, in this case of plaintiff's knee, to normal ranges of motion in order to meet its burden on a summary judgment motion. Also, plaintiffs raised the tribal issue of fact through its own expert because its expert measured plaintiff's loss of range of motion, properly compared those measurements to normal ranges of motion, and opined that plaintiff's injuries were causally related to...
Now, I found it curious that as I reviewed the statement by the doctor in support, he doesn't explicitly say that he actually did the exam of the plaintiff himself.
So
The language is very obscure, so as to kind of leave the impression, but not specifically saying so.
it could have been clearer, but if Your Honor looks to the record at page 112, you can see plaintiff's testimony where he testified that Dr. Berkowitz did examine him, and on page 192 of the record in the
But
doctor's report.
is that sufficient?
Uh,
Don't I need the doctor to affirm that he actually, especially where all the other treatment was his partner in submissions that are not affirmed?
I would argue that he did that on page 192, where he said that he examined plaintiff on December 31st, 2020. That was pretty clear, but also the doctor that he incorporates the examinations of in his report, Dr. White, was his partner who he shared an office
So
with.
what? The fact that it's his partner doesn't mean he gets to just bootstrap that doctor's reports that aren't sent in proper form.
Your Honor,
What case law says that?
yes, Your Honor, I would respectfully disagree. In the case Moon v. Sum, 189 AD 3rd, 628, the doctor there was a partner in the office of another doctor where he affirmed and attached basically the examinations of that other doctor to his reports.
And in that case, was that doctor actively treating the plaintiff? Because here, that is not the case. At best, you have a one-shot examination by the doctor who submitted a statement, right? That's it. He only saw her once.
Well, he saw her at least twice, at least according to the plaintiff's testimony, and that was probably the case.
Was that supported by medical records in admissible form?
Yes, Your Honor, because if you
Well,
look
the
at Moon v.
doctor's
Sum,
records are not in admissible form.
yes, I would argue that they are, because even though they aren't, Dr. White's reports aren't testified to, the defendant relied on them in proving its burden. So the plaintiff is also allowed to rely on those same reports, at least in opposition of a motion for summary judgment. And if you look at Moon v. Sum at page 629, it specifically says that the explanation that the doctors shared offices is enough to consider the non-examining doctor's affirmation on a summary judgment motion.
Okay.
Can you just address causation? If, let's assume we take it that, about the
Absolutely.
causation issue.
Yes, so the case law is well established that a plaintiff's testimony that he was asymptomatic before the accident, along with a surgeon's objective observations of injuries during surgery, are sufficient to raise a triable issue of fact. And in this case, plaintiff testified at his deposition that he never injured or received treatment for his left knee before the accident. That's in the record at page 122 to 123. And Dr. White observed meniscal tearing in plaintiff's left knee during surgery. You can find that at the record at page 194 to 195. And
That's in the unaffirmed operative report.
Right, that was relied upon by both the defendant and the plaintiff.
I don't know that the defendant relied on it.
Yes, Your Honor, I can, if you could just give me 1 second. I believe it was in the record at page 151, where the defendant stated that, or the defendant's expert stated that he relied on.
That he relied on?
That he
That's
that
the
he
words he
considered.
used?
He didn't use those words. but
Yeah.
it was in there that he reviewed it, that it was reviewed. Yes, and it was used to.
But he has to rely on it, not just review it, right?
Well-
He has to rely on the findings in that unaffirmed report in order for it to now be considered by the court.
Your Honor, I
He
would.
has to rely on it, that he reviewed it. If he said nothing about it,
So, Your Honor, I would respectfully argue that because it was in the documents that he reviewed to come to his conclusion, that is a reliance upon.
No, that can't be, because if everybody's deposition testimony is also in the record and then reviewed by the doctor, but the doctor could absolutely discard every single thing that a person testified to, so that's not right, right?
Your Honor.
Just saying, here's what I reviewed, doesn't mean here's what I relied on. Can we agree on that?
Yes, I mean,
Okay.
I would. I would point to.
And let me, just one more thing, as long as we're over the red.
it's all right.
What about all the pre-existing injury and the degenerative nature of what the defendant's plaintiff's expert says nothing about that, correct?
Your Honor, I would say that plaintiff raised the triable issue of fact, at least on an opposition to summary judgment, through his deposition testimony.
No. But in this context, expert has to go against expert, right? It can't be plaintiff says, I didn't have degenerative problems, right? It has to be your expert raising that issue. And your expert didn't say anything about degenerative.
Our case law is very
right?
clear on this issue.
I would respectfully disagree on that point too, to the extent that the degenerative condition was in the plaintiff's own records and not just found for the
Counsel,
first time.
that's fine, but once the defendant's expert says, this is not causally related because the plaintiff had degenerative conditions underlying him or her, then plaintiff's expert must rebut that opinion. And if you don't,
Yeah, Your
you
Honor.
lose on that opinion. You
Well-
lose on that issue.
I'm sorry, Your Honor. Respectfully, the plaintiff's expert did say that very specifically, that the accident caused plaintiff's
Did
injuries.
they address the degenerative statements and findings of defendant doctor?
I would respectfully state.
Counsel, forget the respectfully. We know what that means, okay? You disagree. I suggest you take a look again at this case law, okay? But thank you, we have your arguments.
Thank you for hearing me out. Thank you,
Have a
Your
good
Honors.
day.
You too.
All right. Carwood, is that the one I just did?
Yes.
Yes. DS Infant versus New York City Housing Authority.
Good afternoon, Your Honors. My name is Miriam Skolnick from the firm of Hertzfeld and Rubin, and I represent the New York City Housing Authority. I guess the key issue here is whether or not a settlement was reached between plaintiff and defendant on March 18th, actually on March 3rd, 2022.
Can we agree that on an infant case, even when the parties purport to reach an agreement on a number,
Right?
it doesn't become a formal settlement until the court says, I will approve that?
Absolutely, Your Honor, which is why the relief that we sought was to have an infant compromise order submitted to the court for the court to
But
actually
my point
determine-
is that until it is before the court and the court has said yes,
Yes.
you don't actually have a settlement. What you have is a proposed settlement.
Well, no, you have a settlement according, at least to the second department, that's the only court.
We're
that
in the
held-
first department, so
I know,
let's
but
focus here,
this
because
court-
we have not so held that.
Well, this
So,
court hasn't really addressed the issue in this context. Edwine was a case that was exactly this context.
Okay, again, having practiced in the first department, right? Until that order is in front of the Supreme Court judge who has to either agree or not agree, because there have been plenty of times that the parties agree on a number, take it to the court, and they say, go back to the table, that's not enough,
And if that had happened,
right? So until the court says, yes, submit an infant compromise order, you don't have a settlement.
But-
You have an agreement to agree that the court has to approve, no?
well, what the Court of Appeals has held is that if you have an attorney with apparent authority to settle a case,
On an infant case?
even on an infant case, and,
But I'm saying the case you're citing was an infant case?
yes,
Okay.
then you have at least an agreement enough that you can assume the case is settled. If it breaks down a year later and a court says this is not a fair settlement, there's no court that's going to enforce it, and that's not what we're arguing here. What we're arguing here is that you can't settle a case, indicate that you've settled a case, ask who's preparing the release. Am I preparing it or are you preparing it? And then wait 81 days and turn around and say, we never had an agreement, sorry, my client rejected your offer. When it was the client's demand. It was the plaintiff who demanded the $100,000 and NYCHA who agreed to pay it. And then turn around and say, you've missed your opportunity to move for summary judgment. Because,
That's a separate issue.
Right.
Whether or not you have good cause to move for summary judgment is a different issue.
well,
than
they're
whether-
intertwined, as far
Yes,
as I'm
but
concerned.
You've chosen to start the argument with whether or not you can enforce the settlement, but the
Right.
other argument, which is worth addressing, is whether or not there's good cause based on their representation that it would settle and that you in good faith waited and didn't make a summary judgment motion because
Right.
you thought the case was
Okay,
settled.
then I'll move
I
on.
agree 100% with
Okay,
her.
then I'll move on to that argument, although I will note that it will create a certain amount of havoc in infant cases if the client
No, it
has-
won't. No, it won't.
If you have-
Don't pretend like this
No,
is going to
I
create
will tell you
a
as a-
Pandora's box.
No,
it
not a
doesn't.
Pandora's box, but what I'm saying, because it's very seldom that these settlements break down. But if you have a case, it would be very hard to tell the client, we've settled this lead case with an infant. Don't make a motion for summary judgment. Use the money that you would pay for the motion and kick it into the settlement so that we can reach a settlement and then come back a year later and say, it's one thing
Counsel,
if-
so isn't the solution to that is just to hold that in this unique circumstance, that is good cause for allowing the city to make its summary judgment motion
That would
later?
be our
That's-
position, yes.
That's
Your
right,
Honor.
right? That takes care of whatever worries you have about it.
That if that's the holding of the court, then we're okay with that. And we certainly don't take the position that a court can't turn around and say, it's not a fair settlement, go back to the table. That's never been our position. We just wanted the court to look at it.
Okay,
Thank you.
thank you. You'll have time on rebuttal.
Good afternoon, Your Honors. May it please the court. My name is Christopher Conway. I'm an attorney. I'm here representing the respondents today.
If it's true that
Well,
it was
yes.
a number, the client's number, the $100,000, why shouldn't the court say the settlement has to be?
Your Honor, I empathize with counsel. We've all had to call a client and tell them that we missed a deadline. We've all had to tell them
I'm
how we
not talking
misapprehended.
about the summary judgment deadline. I'm talking about the enforcement of the settlement, and why shouldn't the settlement be enforced?
Because there were
That's what I want you
seven,
to address.
because there were 7 elements to the settlement and only 1 was agreed to. The other 6 were rejected, and counsel has a phone and could call up the plaintiffs and say, where are we with this settlement? We are running up against a hard deadline. And Your Honor, may I just reframe this? This is not about whether or not we have a settlement agreement. This is about Brill. Okay? Brill is controlling in this.
Counsel, she's made 2 arguments. One argument is about whether or not she should be allowed to proceed with summary judgment, but the other is whether the settlement agreement, which you clearly consented to, I don't know if it was you
I
personally.
don't know if it's clearly
but
consented.
Consented to, why isn't that enforceable?
Because it's not enforceable, Your Honor. There were 7 elements, because there were 7 elements to the settlement and only 1 was agreed to, the money. The other elements were
What
not
other
agreed to.
elements are missing other than having it?
I believe that it was listed in there. There were certain documents that had to be done and certain sign-offs that had to be done.
But those are,
Like a
those are par for the course.
And
in
Your
these
Honor,
settlements.
we're allowed to
So-
reject the settlement offer and go forward, and that's what was done. And counsel.
No, wait.
Counsel, that was not what was done.
Well-
On March 4th, 2022, you said, we agreed. You didn't say we agreed to one of the 7.
No,
And then, excuse me, and then you wait till May 23rd, 2022 to say we reject the offer.
Your Honor, I believe that the agreement was only of the dollar amount, but I would say that Judge Bluth got this right. Judge Bluth said that that NYCHA had 3 choices. They could either have their motion ready to go, they could have settled, or they could have done both. And this is, NYCHA, Your Honor, the reason why you can't rule in favor of NYCHA is because they have
We
so much-
can rule in favor of
just saying, Your Honor,
NYCHA.
it would be.
You are suggesting we not.
Your Honor, I suggest that you uphold Judge Bluth's decision and Brill, because if NYCHA is allowed to go through the 120-day limit on
NYCHA, see,
3212.
I reject your premise, okay? And I have been one who is hardcore on these kind of timelines. But where here, they relied on the email from plaintiff's counsel, we agreed, we are settled, then that changes the equation
Well,
completely.
Your Honor, we're not talking about 9 days after.
You waited 81 days to tell them that it was no longer, that what, the last email where you said, we agree, we're settled, that that your client was no longer willing to go along.
And
81 days.
And NYCHA waited 3 months to file the motion. So NYCHA has the obligation to file the motion. We do not. The settlement was rejected, whether it was whatever day it was, they had the obligation to.
No. You didn't reject the settlement that you agreed to until after the time had passed. So regardless of whether they made the motion 6 days or 8 days, they had already blown the deadline because you waited until after the 120 days was passed to say, we don't have a settlement.
Your Honor, I would like to be able to say that, that the attorneys at NYCHA could be so generously moved.
I'm
By
asking,
just
no,
any
no.
counsel, but, Your Honor, let me make this point. They have a very large law organization over there. They know their deadlines. They know 3212A.
So
and they
why
know that they
didn't
missed
you
it.
reject it day one? When they said $100,000, you could have said, that's not the settlement. Let me hear what else. When you're talking about we didn't settle because we had a release, that's general stuff. They wanted releases of liens. That's all stuff that you, as a plaintiff's attorney, should absolutely have expected and known was going to
Correct, but,
happen.
Your Honor, I believe-
So you can't stand here, one moment.
Yes, ma'am.
You can't stand here and pretend that you have no responsibility for how this occurred.
Your Honor, what I am saying is counsel just stood up here and said they were discussing who would send the release. Do you want to do it? Do I want to do it? But more importantly, NYCHA has its own obligations to look after its own litigation. It's not up for plaintiff to alert them, hey, we're coming up against a hard deadline, and Brill controls this from start to finish. It is clear, it is on point, and Your Honor, we ask you, do not allow Brill to be so easily set aside because there
It's
is no
not
good
easily
cause.
set
There's no
aside.
good
And
cause here.
I, quite frankly, when the city has to hire outside counsel to deal with these cases, to say it's okay for the city to be billed, because the city is us,
I agree.
the taxpayer. So we should be hit with yet more expenses from a law firm and a motion that is probably and should not be necessary because plaintiff's counsel has said the case is settled.
No, Your Honor, because NYCHA waited 90 days past the
Okay,
3212A.
I've heard your argument.
Thank you, Your
Got it.
If I may just point out the timeline.
May I just ask you, did you forward all the settlement documents to the plaintiff's counsel prior to the end of your 120 days? That's what my understanding is. You sent the settlement
Sent the
documents,
settlement documents, it was prior to the,
and then the
And then we heard nothing.
plaintiff waited till after the deadline, and said, oh, no, we're not going to do this. Is that correct? Am I correct in that?
correct.
Okay.
so it was, our motion was made 104 days after the deadline, but 81 of those days was during the period of the settlement. Then we'd be working on the motion.
Okay.
Thank you.
Thank you. People versus Rosemary Hernandez. Judge Rosado is recused on this case. If there is a tie, we will vouch someone in, as per our rules. All right.
May it please the court. Abigail Everett for Appellate Rosemary Hernandez. Preliminarily dealing with the appeal waiver in the case, this is a classic instance of an invalid appeal waiver. You've got the judge going through the Boykin rights that the defendant waives, every defendant waives when he or she pleads guilty, and then immediately saying, now also as a condition of the guilty plea, and then going into the appeal waiver. So that creates the impression this is part of everybody goes through in the guilty plea waiver. I want to point out that Ms. Hernandez, this is her first contact with the criminal justice system, and also point out that that the court never explicitly said to her, usually people, when they plead guilty, retain the right to appeal. That warning is the very first statement in the CJI model colloquy for appeal waivers.
But there is no requirement under our case law that a judge follow any particular colloquy, right?
Absolutely
and
right.
we are to take the waiver, not just the verbal explanation by the court, but also the written waiver, which, do you have an objection to the written waiver?
I think there are a lot of cases that say that the written waiver cannot cure, no matter what's in that written waiver, cannot cure a faulty oral waiver, particularly since you have to look, again, in the cases that you look at the totality of the circumstances of the case.
I think you have some other stronger arguments and
Well-
that I would suggest.
Okay, well,
most
going
respectfully that you
beyond,
address.
if I can convince the court that she has not waived her right to appeal, that we ask the court, in its interest of justice, to reduce her sentence. I want to point out, this is a situation where the prosecutor below conceded that Ms. Hernandez was the victim.
And the court took that into account, right? The court knew and agreed that this was a domestic violence case under the statute and sentenced her accordingly, right? She could have had a much harsher sentence. And the court below said, yes, we all agree, this is a victim of domestic violence. I'm going to sentence her to this sentence based on our new or not so new anymore, statute, right?
Yes.
So how, so
Well, because,
why
Your
should
Honor,
we, why is that incorrect? What did she do that would require us to change the sentence?
it's a sentencing range here of 5 to 15 years when a person who's the victim of domestic violence commits a murder in the second degree. This is not a case that calls for more than that minimum sentence of 5 years. She's a first offender in her 30s. She was 1 month postpartum at the time that this crime occurred. She has 2 young children that she said to the court, I really want the opportunity to be a mother to my children. This is not about victim blaming, but this is a circumstance where she was living in a household that DA acknowledged where she was being abused. There is nothing about this case that merits more than the minimum sentence of 5 years for any domestic violence survivor. The people made arguments at sentencing why they thought that that the 10 was the right, but I would ask the court to look at it. They were things like that the complainant, the victim, was 21, that the DA said that my client did not call the police. Well, there were other people in the household, they called 911 and the police responded. There's really nothing about this crime that merits more than the minimum sentence of 5 years. I would point out that this is a woman who has had an extraordinarily difficult life. The New York State Legislature has acknowledged that these cases are different from the average case where you have a murder in the second degree. And the statute says you don't need to show that this is a justification defense. You don't need to show that this is a situation of duress.
So let me just direct you sort of to the post-release supervision.
Okay.
Right? Because that,
All right.
regardless of the waiver, that survives, right?
Okay, and again, as I argued, this is really a case of first impression for this court. The statute says explicitly, notwithstanding any other provision of law. I think we all know that there are lots of cases that is signal language that say you really examine what this statute says in the context of this statute. And in that statute, 60.12, it does not provide for post-release supervision for people who have been convicted of murder in the second degree. And I would ask the court for that reason to find.
Should we take from the absence of language one way or the other? Because the legislature, in considering this act and all of the policy reasons for its enactment, knew that on a murder 2 conviction, post-release supervision would be automatic. They could have included language that would have exempted this statute and this act from that section that imposes PRS on anyone on certain felonies, and certainly murder 2 being one of them. Why should we infer from their failure to so exclude it that they meant to exclude it?
Well, if you look at the legislative history that's cited in Appellate's brief, you'll see there's a lot of discussion there about the history of, in this case, women who have been convicted of murdering abusive domestic partners, and the person who proposed this legislation stressed that there was 0 incidents of what's the word I'm looking for?
Recidivism.
Recidivism, thank you.
But that's all the more reason, because I don't disagree with you.
Right.
Okay, I personally don't disagree with you that a person who is a victim of domestic violence and finds themselves in this situation is likely, after release from jail, to do this crime again. It was a crime of passion. So I agree with you. But again, the legislature understood precisely why they were enacting this statute and chose not to exempt it.
But they did state, notwithstanding any other provision of law, the sentencing is what's here in 6012. And I will say that there's also indication in the appellate's brief about how difficult post-release supervision can be for women or people, I should say, who've been through domestic violence. And we don't want circumstances where people get caught up on technical problems that because of their life history, they may have trouble dealing with and sent back to prison.
Right, but this is a statute that sort of changes the statute. So really, isn't the solution to go back to the legislature and say, fix this?
Right, but if you look at 70.45, the legislature
I don't
did
think
change.
that that's exactly right. They're not inconsistent. So that's the problem. That as appealing as the argument is, if the legislature doesn't do it,
Right. I mean, the legislature did change explicitly for other levels of felonies that what the post-release supervision would be and said nothing about murder two. I would submit that meant because they understood it wasn't going to apply to murder two. Thank you.
Thank you. You may proceed.
Good afternoon, Your Honors. May it please the Court. Elliot Hamilton for the respondent people in the state of New York. I just briefly, with respect to the waiver of the right to appeal, the oral colloquy pointed out that this was a separate and distinct right, and the written waiver also, and written waiver said that to that effect, and the oral colloquy also included language as to what rights survived the appellate waiver on this end. So our position is that the waiver forecloses review on the excessive sentence claim. With respect to the PRS argument that my adversaries bring up, both Your Honors are correct that with respect to the statute, notwithstanding other provisions of law, specifically focused on the carceral sentences that a DVSJ finding would permit for defendants who are found to be survivors of domestic abuse. In this case, the statute is silent with respect to post-release supervision, but by operation of law under Penal Law Section 70.45, every determinate sentence generally must also be coupled with a term of post-release supervision. With respect to the balance of equities regarding this particular defendant, this defendant is indeed a first-time offender, and we conceded was a longtime victim of domestic abuse. I submit that post-release supervision in this case, where the defendant was found guilty of murder in the second degree and didn't get 10 years as a totality
Well,
of the
pled
conduct.
guilty.
She pled guilty to it, but the 10-year sentence was offered in totality of not only her being a domestic abuse survivor, but also the nature of the act.
But counsel, wouldn't you agree, really, this is a case where there's literally probably no chance of recidivism, right?
There's
very little. So
there's an increased likelihood. Is there a decreased likelihood of her being a recidivist? Sure, especially in light of her spending 10 years in prison for committing intentional murder. But the benefit of post-release supervision is that while she is under post-release supervision, she will have certain access to other services and other supervision for services that she did not get during those 10
yeah,
plus
but
years.
also she could be rearrested.
But the services she needed back then was to get this man to stop beating her. That is no longer a service she needs, obviously.
Of course not, Your Honor. But to that effect, I think a term of notwithstanding other provisions of law was specifically related to the carceral penalties that are altered under Penal Law 60.12 with respect to certain certain crimes that an offender can plead guilty to. And it remains silent as to PRS terms.
Is 5 years the lowest amount of PRS that can be given under this?
I believe it is the maximum. It is the maximum amount. And
so what is the minimum amount of PRS?
Give me one moment, Your Honors. Period of post-release supervision for any offense other than a felony sex offense shall be 5 years, except that such period shall be less than 5 years for certain convictions, and that's for related to Class B, C, D, or E felonies.
Which this is not.
But this is a Class A felony.
Okay.
So I would say that this might be the minimum. This might be the minimum on this end of it. And I think for the balance of equities, given the totality of the circumstances of this very sad and unfortunate case, the defendant did get 10 years on an A1. The court found this to be acceptable. The defense found it acceptable. The prosecution did. The victim's family did not, and that's part of the reason that the court took into consideration as well to keep it 10 years, which is dead smack in the middle of the range between 5 and 10, to ensure that the defendant was at least held accountable for the actions while also receiving the recognition that she did survive a tremendous amount of domestic abuse, and we took that into consideration. We ask that you affirm.
Thank you. You have 2 minutes.
I would propose that if the court is not inclined to eliminate the post-release supervision, and knowing that she's going to serve 5 years of post-release supervision, that would be an appropriate factor to take into account in deciding how much time she should be in prison before she does that 5 years of post-release supervision. So, for example, if she does 5 years in prison and then 5 years of post-release supervision, I think that would be possibly a way to resolve this if the court does not agree with me that the statute doesn't provide for it. And I just would point out one minor change to what my adversary said, talking about the appeal waiver. I believe he said that the court talked about what rights survive the appeal waiver. One of our points is that the court did not specify what rights survive the appeal waiver. This is a very bare bones in that regard, and I would ask you to take a look at this appeal waiver, that it does not meet the requirements of a knowing and voluntary waiver, particularly for a woman who is never in her 30s, has never before been arrested. And I would ask you to put aside the waiver and reduce her sentence. Thank you.
Forrest Walnut versus Abziger. You may proceed.
Good afternoon, Your Honor. May it please the court, my name is Glenn Wertheimer of counsel for Chris Cardillo. The November 22nd, 2022 order by Judge Nancy M. Bannon is without jurisdiction. It was made 1 day before the return date and is jurisdictionally defective and is void. And frankly, I've never heard of anything ever happening like that before. The return date in room 130.
The reply was due before the return date, correct?
The reply due before the...
Your opposition papers were due before the return date, correct?
Yes, that's...
6 days before your return date, correct?
Yes, Your Honor.
Notwithstanding the fact that you had a consent to adjourn that motion, you neglected to file that consent adjournment, and the court issued a decision the day prior to its return date.
Yes, Your Honor, but the procedures in room 130 allowed a stipulation, or basically a affirmation to be filed with the court. So we were not allowed to do that.
Do court rules supersede the CPLR rules?
Well, we were just following the procedures in room 130, which is...
Counsel, you had the benefit of a consent adjournment. You failed to file it. The court asks, why should you be relieved when you dropped the ball? And that doesn't, I haven't even begun to address the lack of merit of the cause of action you are seeking to pursue. That's a totally different issue. But just procedurally, why should you get relief when you had the relief you wanted, which was more time, and you couldn't even follow up and exercise the due diligence that was required of you and file the consent agreement you had?
Yes, well, we probably should have, Your Honor, but it wasn't done. But still, the procedures and Rule 130 allowed us to file an affirmation, which we did.
All right, so now explain to me why this claim that this landlord is somehow liable in negligence for renting to the Abzigers, who then took your client for a ride, for lack of a better word, right? Because that's what we've got here,
Yes, Your Honor.
right? The Abzigers rent space from Walnut, right?
Yes.
And that's it. They just rented space from him. How is Walnut responsible for the acts of their tenant?
Walnut did no investigation who they were.
And what duty requires them to do an investigation to rent space in their space? I know of no case that requires a landlord to investigate their prospective tenants.
It wasn't, just to add on to it, it wasn't even their tenant, it was a subtenant. Yeah. So there's not even any privity between them and your client, because they leased to a tenant who leased to Abzigers, so it's twice removed. So how can there possibly be liability in those circumstances?
Well, the defendants, they basically had no idea who was in the office. They did no investigation whatsoever to see if they were fraudsters, which they were.
Why did they have any obligation or duty to do any investigation?
Because they were using their telephones, they were using their cards to get in and out of the building, they were using their common areas, they were using their office space, and it gave an appearance that these people, these fraudsters, were working for that company.
Is there any allegation in the complaint that they somehow had any notice whatsoever of anything fraudulent about the defendants? Not about the defendants, about the Abzigers?
Any notice whether or not they were fraudulent?
Whether these defendants that you decided to sue had any notice whatsoever of anything fraudulent or anything incorrect or anything wrong that Abzigers did?
I'm not sure what you're asking, but the only notice that we had that...
Not that you had. You're saying they should be held liable for a subtenant's actions.
Mm-hmm.
What basis is it? What put them on notice? Where's your allegation that they somehow knew that these were bad characters?
That would rise to a duty.
Mm-hmm.
That's my question.
Well, they should have done some investigation of who was using the office.
So you're saying if we were to take up your suggestion, we would turn New York real estate on its head, because now every single landlord has to investigate every single tenant that they lease to?
No.
Does that sound right and reasonable to you?
No, we're not trying to open the floodgates of litigation, but
So
this
then
is very
tell,
specific.
again, I keep on asking you, and all you keep saying is they should have investigated. Under what theory of law did they have a duty to investigate? I'm missing that part, because there can be no liability if there's no duty.
Well, they created an appearance of a connection to respondent.
They created, or the Abzigers did?
No, they created.
How did they create that?
They created that by having those people, those fraudsters, in the space that they worked in. These people, the defendant and the respondent.
Counsel, your paper said, they should have investigated because people were coming in to visit the Abzigers and were influenced by the finely appointed offices. I mean, really? So someone rents space in their nicely appointed office, and that creates a duty?
Well, it can, because they basically, they had were using those telephones, they were using the spaces.
Counsel, that happens a lot, and more after the pandemic. People are sharing office space. So this is not an unusual occurrence.
And there was no separate sign, Your Honor. There was no sign by the door saying Virgo or Virgo 1345 Business Centers LLC. So it gave the impression that these fraudsters were with the same company.
Okay, I'll hear from the other side.
Good afternoon. May it please the court. Brian Burns for the respondent.
Am I missing something?
No, Your Honor. You have it exactly right. The court can easily affirm on procedural grounds. They can't appeal the motion to dismiss because they didn't oppose it, and they don't prevail on the motion to vacate because they don't have a reasonable excuse. Letting your opposition deadline go by days without notifying the Supreme Court that you have an extension in place, that's not reasonable. And it's also clear that the Supreme Court was unquestionably correct on the merits, and certainly well within its discretion, which on a motion to vacate, which is really the only thing they can appeal, is what we're looking at here. So this negligence claim, it's an attempt to expand common law premises liability principles to create a new breed of secondary liability for alleged financial misconduct of others. So Alliance Bernstein's the tenant in this office building. They're a lessee. They sublease space to an entity called Virgo. Virgo operates a business center like a WeWork. And the other defendants of Bizkers apparently lease or use some space that Virgo offers. And this claim basically seeks to require Alliance Bernstein to control the conduct of Virgo's customers or else face liability if those customers breach those contracts or commit fraud. There's no basis under New York law for that kind of claim, as I think the court well understands. Plaintiffs can't make the required showing for a duty that Alliance Bernstein would be in the best position to protect them from this kind of deal gone bad harm. There's just no relationship between the plaintiffs and Alliance Bernstein, other than they visited the office apparently. There's no relationship between the Bizker defendants and Alliance Bernstein. And the plaintiffs, they're investing in this deal. They have an affirmative duty under New York law to do their own due diligence. So you can't say that Alliance Bernstein is anywhere close to being in the best position to protect them from this kind of harm. And it really will open the floodgates if you let this kind of claim go through. And one point I think Your Honor sort of hit on is the conduct that they're talking about to create the appearance was done by the Bizker defendants. Nothing was done by Alliance Bernstein. Right. Alliance Bernstein is just the landlord in all this. And if you even, to kind of suggest that a landlord has a duty to a tenant's counterparties to take steps to prevent them from acting in a way that creates an appearance, you're opening the door to serious issues and unmanageable consequences, and that's exactly why you have the analysis of whether a duty exists is a question for the court. And I'll just submit here, it's not. There's no cases that support their theory. Even if there were somehow a duty, there's no negligence because there's no indication that Alliance Bernstein knew or from past conduct should have known that someone like these Bizker defendants would try to manufacture some kind of an appearance of association with Alliance Bernstein to defraud someone. And for similar reasons, there's no causation as a matter of law. That kind of fraudulent conduct is just unforeseeable as a matter of law. And I realize I have a little time remaining, but I'll concede unless the court has any questions.
Thank you. All right, counsel, you have 1 minute.
Again, the defendants were negligent in the way in which they managed and sublet its office space. And they should not have let those cards be used by people that were fraudsters. And I think it's evident. And again, it's not going to allow the floodgates of litigation because this is very specific. That's all I have, Your Honor.
Thank you.
All right.
Spalter versus Spalter.
Excuse me. May it please the court. My name is Bryce Levine from Jeffrey Schechter and Associates. We represent the appellant Michael Spalter in connection with this appeal. The issue on this appeal boils down to the following. Did the lower court err when it denied appellant's motion to dismiss and issued a declaratory judgment that the parties were married, notwithstanding the uncontroverted evidence in the record that supported a finding to the contrary?
Something, isn't it somewhat undisputed that you can be married in New York without a license? There's clearly case law authority saying that you don't have to have a license to be married.
Well,
Are you
there's sort of a dichotomy. I'm
What?
sorry. There is a dichotomy there. Domestic relations law section 13 does require the parties to get a license.
Right,
Domestic-
right, but there's also clearly, it's not really disputed that there's case law out there that even without a license, people can be considered married. And one of the main things that you look to is if there's a valid religious ceremony that both parties entered into and when they got married, that is enough. So why in this case, where there was clearly a very traditional wedding ceremony, a rabbi officiated, they represented themselves and agreed that they were married under Jewish law, why isn't that sufficient, and what was incorrect about what the court held below?
Well, for two reasons. One, the statute, and I believe Your Honor is referencing Domestic Relations Law 25 and the cases that have relied on that statute. It says that a marriage is not invalidated solely because of the lack of a license. But that doesn't mean that it's automatically validated.
I didn't
because
say that. My question specifically is because of the nature of the ceremony in this case, in the facts of this case, where they represented they were married under Jewish law, they had a very formal ceremony. Why isn't that sufficient under our law to find there's a binding marriage?
Because under Domestic Relations Law 12, it defines what is necessary under law of the state for a marriage to be deemed properly solemnized. And that statute says that the parties have to represent to each other in the presence of the officiant and a witness that they are taking each other as husband and wife.
But didn't they specifically recognize in the document that they were married under Jewish law? Why doesn't that satisfy their requirement?
Because that document also says other things as well, specifically that this marriage, quote unquote, would not be recognized under civil law and that there would be no legal, financial, or custodial consequences associated with this unless it was subsequently solemnized in a subsequent civil ceremony. Something was done in this ceremony.
Don't we have case law in New York that what the parties say does not have to be enforced? If they do the things that make them married, the fact that they say, hey, we're not married is not enough by itself necessarily to make them not married.
Well, I
That's
think
not the determining factor.
You don't get to decide that necessarily by just saying that, hey, we're going to hold out, we're going to have a real ceremony, we're going to go before a rabbi, we're going to agree we're married under Jewish law, that under New York law, you can't necessarily then just turn around and say, hey, but we're not married under New York law. Particularly where there's 4 children.
Two of which were born after this Jewish marriage.
one of them was already conceived, and the wife was Miss Weeder was pregnant at the time of the April 1st ceremony.
So why under all those circumstances where there's a presumption of validity of marriage, they represented themselves as being married under Jewish law? Why isn't that sufficient since our law is very clear that you don't need a license?
Because of the fact that the ceremony did not comply with the civil laws of the state, specifically Domestic Relations Law Section 12. They did not represent
But our
each
case
other.
law doesn't say it has to, right? That's the whole, we have to analyze not just the statutory provisions that apply, but also the relevant case law that has developed in our jurisdiction, right? And so I understand why you keep on focus just on the statutory language, but it's kind of at odds with some of our, it has evolved in our case law to allow for the recognition of a marriage where there has been a religious ceremony, and I still haven't heard why that isn't enough.
Well, because also the case law also talks about, and there's developing case law in the Supreme Court of this department, where you have to look beyond the ceremony. Even if the parties were married, properly solemnized, if there was an abject lack of consent to be married, as was the case here, the court can find that these parties were not married and recognized in a legal marriage under civil law. And the Devora H case that Judge Cooper had decided several years
Why
ago,
can't we find that this, and you do need consent, that is correct. Under law, you need to have consent to marriage. But why was it improper for the court to find that that consent existed based on their express acknowledgement in front of a rabbi and in a document that they were married under Jewish law?
well,
In front of a rabbi and 29 witnesses.
well, a lot of those witnesses were people that were just at the synagogue that day. But notwithstanding that, the document that the parties signed specifically said that they weren't entering into a marriage that was recognized under civil law, and all of their actions after the fact, tax returns, the filing of legal documents, visa.
Counsel?
When you say
Counsel?
tax returns, did you put in any tax returns?
No, and
No,
and
don't
that's-
say
and that's-
tax returns. Let's just talk about what's in the record, right?
But I
I
was
do want to
just gonna-
respond to that, to the issue of the tax returns, because the wife Miss Weeder submitted a net worth statement in her papers that referred to tax returns that were not attached.
Okay.
And those tax returns, if they reflected that she was representing herself as married, would have been attached.
I only am saying to you that on appeal, you may not discuss evidence that wasn't submitted below. That's all.
I understand that, but
I just wanted to ask, does your client refer to her as his wife online? Does he put posts saying, this is what my wife thinks?
I believe there were a couple of posts in the record where they were talking about issues that concerned the children. But the evidence that is in the record, not just by my client, but by the wife, and not just by her words to my client, but by the documents that she has submitted for visa applications, remain to stay applications, citizenship applications, all in which she represented herself as unmarried. Those carry significant weight. She's representing to governmental authorities that she's not married. She's receiving benefits that based on her not being married that she would not have received otherwise. She represents to my client in multiple communications that they are not married. These parties acted for 15 years like they were not married. She's telling him that he should.
Well, no, wait a minute. They told their church they were married, right? Their synagogue, they were married. They acted as if they were married for purposes of getting their children into certain programs and schools. There were situations where they held themselves out to the world as married, correct?
No, they obtained a ketubah to enroll their children in Jewish school.
And did they, in fact, do that?
Well, that was the only reason why they
I'm
went.
just asking.
Yes, they did
Yes,
do
of
that.
course. So you don't say, you didn't, when they went to the school, they didn't say, we're not really married, did they?
Well, I don't.
I doubt it.
I don't
But
know.
you'll have time on rebuttal.
Thank you, Your Honor.
Classic.
Good afternoon, Your Honors. For the respondent, Jad Greifer from Cohen, Clare, Lands, Greifer, and Simpson. I think Your Honors understand it and have it right, so I'll be brief.
I just want to ask you about that one sentence in the agreement that says, this marriage won't be a marriage until we get a civil license. How do you respond to counsel's argument that that statement shows that neither one of them were consenting to be married?
So just to break down that statement, they said they were married under Jewish religious law, and that makes them married. And the Shields case from this department says very clearly you cannot get married in name only. You cannot opt out of the civil law of the state of New York by saying we're only getting married religiously and we're not going to get married civilly. You cannot do an end-around prenuptial agreement to deprive your spouse of her financial rights by doing that. And the law in this state is repeatedly clear. DRL 12, which Appellant's counsel cites to, says very clearly that no particular form of religious ceremony is required. It's what's customary in the particular religion. And as the pictures that are part of the record make explicitly clear, this was a Jewish religious ceremony in every possible respect. Judge Katz understood that.
And then how do you explain your client's post-marriage statements about not being married?
She thought she was married religiously under Jewish law, and she thought she was not married under civil law. She did not know what New York.
She's not a lawyer.
She's not a lawyer, but their subsequent conduct, and case after case makes clear that your subsequent conduct is irrelevant. If you are married under a religious law, in this case, Jewish religious law, end of the analysis. And these parties were married. This idea that the vows did not follow a particular wording, first of all, there's nothing in the record that would support it. You cannot create a shadowy semblance of an issue of fact. The facts were clear. These people had a Jewish wedding. They're married under religious law. New York State says even if you don't get a wedding license.
The Jewish marriage contract says, be thou my wife, according to the law of Moses and Israel, et cetera, et cetera.
Exactly.
So
They signed it.
it was clear and it was signed by both parties.
You had the ketubah, you had the stomping of the glass, you had the hora.
So it's your position that their post-marriage conduct is irrelevant?
That's correct, and it's not just my position. Case after case says that you have in a state of Harold H., Prasad versus Balsam, NB versus FW, and as the Shields case, as I mentioned earlier.
Because actually, people could get married civilly and then never live together and never do anything together and live separate lives too, right? And they're still married.
They're married.
Exactly right, Your Honor. Thank you, Your Honors.
Thank you. Okay, you have 2 minutes.
Thank you, Your Honor. The statement that there's case after case that talks about the court not looking at post-ceremony actions, there are multiple cases in this jurisdiction that talk about, that do exactly that. The Devorah H. case decided by Judge Cooper in the New York County Supreme Court. The Jackson...
It's actually distinguishable, though, in terms of the ceremony that was held in nowhere was the same level of ceremony that was held in this case.
Yes, but the ceremony, but there are similar characteristics to that. In this case...
Wasn't there some real question whether that even was a ceremony in that case? Unlike in this case, where it is pretty clear that they had a Jewish ceremony and they considered themselves married under Jewish law, where that was not at all clear in the case that you're referring to.
Well, the Devorah H. case, the court did find that they were legally married. And there are similarities between the two, because in this case, these parties did not plan this wedding for a year or two. This was hastily planned. Mrs. Weeder was the one who contacted the rabbi to try to obtain this ketubah so they can enroll their daughter in religious school in the UK. And it wasn't until March 27th that she received something back from the rabbi saying that he could perform whatever was needed to be done to enable them to get this ketubah. And then 4 days later, they went and did this ad hoc ceremony in the basement of a synagogue. The fact that there were people there, it's the beliefs of third parties that were there is not the issue here. It's what the parties believed. It's what they consented to. It's what they had the justified expectation.
Going back full circle, they signed an agreement, didn't they, that said they were married under Jewish law.
But that doesn't mean that that is recognized under civil law of this state.
Okay, yeah, we're going in circles.
But-
Thank you. We're out of time.
Thank you.
Okay. Diaz versus P&K Contracting. Judge Scarpula is recused on this case. Should we have a tie, a judge will be vouched in, and we will follow the rules of the appellate division in that regard.
Good afternoon, Your Honors. May it please the court,
Give me 1 second, let me put the clock on for you. Now you may proceed.
Good afternoon, Your Honors. May it please the court, Jessica Bove from Perry, Van Etten, Rosowski, and Kuttner for the appellant P&K Contracting. Our office moved for the appeal on 2 grounds, contending that it was erroneous, the court's decision to deem TDX as not a proper labor law defendant.
Let me ask you that. How can TDX be a statutory agent under Labor Law 240, where the actual contract explicitly states that it is not responsible for managing the subcontractors, and it's not responsible for means and methods? Isn't that the exact test that we need to apply to determine whether an entity is a statutory agent?
That was not my understanding. When I did read the contract, there were several provisions in the contract which gave TDX broad
They
responsibility.
gave them general.
It says TDX shall not have control over or charge of the work and is not responsible for the contractor's means or methods or for safety precautions which are solely contractor's responsibility. Why doesn't that language preclude as a matter of law TDK from having statutory agency status under 240?
And hasn't been their case law in this department that so holds, that where there is that language in a contract, there can be no finding of agent.
Well, there is language also in the contract that says that TDX was responsible to proactively monitor the progress of work.
But we have many cases saying that kind of very, very broad language is not sufficient. This isn't even a case where TDX was, you know, the general contractor on the job, and we're talking about a subcontractor. TDX didn't even hire any of these people. It really has no relation.
Well, TDX was functioning as, yes, the construction manager. However,
It's different than a general contractor.
but their behavior at the site was different. Even Dominic
What's the
Reed.
proof that they supervise and control this work in any way,
Well,
shape, or form?
Dominic Rita testified he was the project manager for TDX. He indicated that TDX did serve as the agent for NYCHA at the job site. And in addition to that,
That wasn't my question. What evidence is there in the record? Because the test is that you actually exercise some control at the work site. What evidence is there?
I was going to get to that point. Kashawn Bridgewater actually provided an affidavit that indicated that she was there at the time of the accident where the delivery unloading was happening, and she was monitoring that work that was being
Say
performed.
unload it one way versus another way, don't unload it this way, unload it that way. Did she have any role in directing this worker how to unload the materials from the truck?
No, but she was directing the tenants to make sure that the tenants were not interfering with the work so that the men could work
But
in a
how
safe
does that
manner.
control the work, the injury-producing work, which is what is required for a finding of liability, right? So TDX would have had to, as my colleague has just said, get inside the truck and hand the pieces of material. There is no evidence in the record that they did anything like that.
I don't believe the case law is that strict.
That is exactly what the case law says.
The contract indicates that TDX had an obligation to implement safety measures and endeavor to safeguard safety for the men at the job site, and that's what Ms. Bridgewater was doing at the time of the incident.
That's a very general supervisory role. It is not specific as to the method and manner of the work, which is what is required under our case law. Do you have other issues you want to hit?
Yes, but I also just want to refer back to Walls versus Turner. If you see the types of things that construction manager was doing at the job site is similar to what was being done by TDX at this job site where they were monitoring the work.
In Walsh, did the contract have a provision like the one here that specifically said that this particular company was not in charge of and did not have control over the manner and method of the work?
It did not, but I also, I do want to highlight.
I got to tell you, for us, that language is really vital here.
But then there's also language that says that TDX was responsible to take corrective measures if the contractors are doing anything in an unsafe manner or unsafe work condition. That's in the contract.
All right. You'll have time on rebuttal.
Thank you.
You may proceed.
Good afternoon, Your Honors. Joshua Annenberg for the plaintiff appellant Diaz. I'd like to go exactly where this court was questioning because the issue of TDX is very much at issue in our appeal. With respect to the issue of the means and methods, I understand what Your Honor is saying. However, the very next sentence says that the CM, the construction manager, shall, however, have the requirement and right to implement an immediate stop work order or a corrective
Counsel, we
action.
have so many cases that say that that is not enough. I mean, we have a legion of cases that say that.
I understand.
That general ability to stop work is insufficient to impose 240 liability.
My response is twofold.
There's gotta be evidence that they in somehow, even a little bit, instructed the workers on the manner and method of the work.
According to Walls, and if you look at my brief at page 13 and 14, I lay out what I call the 12 or 13 overarching legal obligations that provide that mandate that they have broad responsibility and authority and supervision over the job site itself,
So
which by
talk about the
Walls,
specifics of this case. What supervision and control did they exercise over
They
how?
were-
Counsel, you didn't even let me finish my
I'm sorry.
question.
I
How-
truly am.
I know you're going to guess what my question is, but how the work was actually performed in this case, how the materials were unloaded from the truck. What evidence of there is that they supervised that?
with respect to the construction manager itself, TDX, they had a person there on site at all times. What she was doing, quite frankly, is doing nothing, looking around and doing nothing. She abdicated.
Supervising them.
She abdicated her responsibility. Now, but what I would also like to do is to place.
Wait a minute, what was she supposed to do? Stand?
Well-
Let me finish. Was she supposed to stand by the truck and wait for all the delivery to be done before she could go back to her office and do work?
Well, if.
Counsel, we entertain a lot of labor law cases.
I understand.
So we see fact patterns you haven't even begun to see, okay? So I mean, we're asking you very targeted questions based on our understanding and application of the labor law of this department.
I understand.
So my colleague has asked you several times, and you never answer the question. What specifically was said or done or directed to be done with regard to this particular work that caused this particular injury?
She abdicated her responsibility.
That's the lack of an act.
I'm sorry?
The lack of direction.
The lack of direction. If what she is supposed to do based upon the contract.
Let me.
I'm so sorry, I get so excited, I'm sorry.
Contract specifically says that TDX shall not have control over how the work is performed and is not responsible for, so you keep saying she abdicated responsibility, but the contract expressly states that that responsibility doesn't exist.
What I want to do, though, is ask the court to look at the very next sentence. The construction manager, however, shall have the requirement, a mandate, and a right to implement an immediate stop work order or a corrective
We're
action.
going full circle. So let's
I know,
let me
I
ask-
understand
let me
that.
ask-
Would I
we
like to-
didn't like it the first time, so I don't know if we're going to like it more this time. Let me ask another question. What evidence, and this is a separate question, is there that P&K controlled or supervised the work being performed? in this
Okay.
case? Since that's another part of your.
I understand that. So P&K had a person on site named Kairav Tripathi. So if you look in the record and you look in my brief, I discussed where Tripathi said, yes, he testified. Yes, I did supervise. Yes, I did give instruction. And then he walks it back. He says, well, you know, maybe I didn't. And then when we ask him some more questions, he goes, I don't really remember. And he tries to fob it off onto TDX. But he did testify quite literally that he did provide supervision, direction, and control. And he was there. And if I could also just shift for one moment to a procedural context.
I'm going to give you 45 seconds to
That's
give me
fine.
that procedural context,
I-
okay?
I appreciate that. The procedural context, and as I discussed in my brief, really is that TDX has not sustained their evidentiary burden in moving for summary judgment. If the court were to go back and look, not just at the issue of the means and methods, but at the very next sentence, and also with respect to what I bring out in my reply brief, is a case in the Court of Appeals that under contract law, and this is a contract, you have to take the entire contract as a whole, and you cannot isolate one little provision. And to the extent that they moved for summary judgment, it was their requirement to essentially disprove the elements that they were the construction manager and they had the broad authority. They did not do so. They only talked about one isolated matter in the contract, did not reference any what I call in my brief the 12 overarching contractual mandates.
Okay.
Thank you.
Thank you. Next.
Good afternoon. May it please the court. Ira Goldstein with Morris, Duffy, Alonzo, Faley, and Pickoff for respondent TDX. I mean, your honors pretty much touched on the most important points. I want to address Walls, which everyone has addressed, which the lower court also relied on and found that you have to delegate the required control over the work, which did not exist. And in Walls, Turner Construction was not only the construction manager, they were the general contractor. They covered everything. So Walls has no applicability as far as TDX's role, because TDX was strictly a construction manager. Their single representative on site had a very limited role signing workers in and out, noting the number of workers present, reporting progress, the typical roles that time and time again this court, the Court of Appeals, every part of the Appellate Division is found to be unactionable. And as Your Honor touched on, this contract specifically excludes any responsibility for directing, controlling the means and methods of the work. And as far as stopping the work, again, that's time and time again insufficient. So if Your Honors don't have any questions, we will rest on our brief.
Thank you.
Thank you.
Good afternoon, Your Honors. Carrie Wareheim from Scahill Law Group for the third-party defendant, respondent Steel Construction. Initially, the lower court, in granting plaintiff's summary judgment motion on the Labor Law 200 claim as against my client, his employer.
You didn't appeal, though, right?
We did not file. We did not
If
file.
you didn't appeal, how can we consider any relief that you, even if you were right in your arguments, and I think you probably do have some good arguments, how can we even consider them where you haven't appealed?
Well, I would argue that this appeal is being appealed under a record format, not an appendix. So the court is in possession of every single paper that the lower court had.
We don't do that.
You still need to move to, I mean, yeah, you need to move to appeal to get some relief.
Well, it does not afford the other parties an opportunity to respond, and that would be unfair. So we don't do that. If you don't move, you don't get relief.
Okay, well, I would just.
Appeal. I'm not sure why you didn't appeal, but.
Your Honors, if I could certainly go back in time and file a notice of appeal, I would. But considering that the plaintiff did not request Labor Law 200 against his employer because he did not file a lawsuit against his employer.
I don't know where the claim is going, but that's neither here nor there since you didn't appeal them.
Right, okay, so Your Honors, addressing the entitlement, the lower court determined that P&K is entitled to contractual indemnification against my client. And this issue goes hand in hand with the plaintiff's appeal regarding the Labor Law 200 claim against P&K. And we would argue that there are triable issues of fact as to whether P&K supervised the work, controlled the work, and in that instance.
Don't you want it to be dismissed against P&K?
Excuse me?
Don't you want it to be dismissed against P&K because then you'll have no indemnity issue?
Well, as of right now, the court granted summary judgment against us on contractual indemnification.
Right, but if there's no liability, then there's nothing to indemnify. It doesn't matter, forget that.
Finish your thought.
Thank you, thank you. As of right now, the court has deemed P&K's liability against steel and construction based upon vicarious liability alone. And we would argue that if the court finds that tribal issues of fact exist as to P&K under Labor Law 200, then the summary judgment entitlement under contractual indemnification should be reversed.
or modify to make it conditional?
Of course, Your Honor.
Okay, all right.
Thank you.
Thank you. All right, and you have rebuttal time.
With regards to Steel Construction's request for reversal of the granting of P&K's dismissal for Labor Law 200, if you see in the record, P&K was just providing general supervision. They did not direct how steel construction workers were supposed to erect the sidewalk sheds. They were not involved.
Neither did TDK.
Correct.
Right.
They were not involved in the whole delivery process. Steel Construction loaded the material at their own warehouse in Queens, transported the vehicle to the location in the Bronx, and had their own workers unloading the material. And P&K was just there to provide general supervision. In fact, Mr. Cairo Tripathi testified that he did not witness the accident itself. The person who witnessed the accident was the TDX person, Kashawn Bridgewater, and she was there and she was able to witness it because she was monitoring and she was trying to prevent tenants from interfering with the workers while they were performing their job duties.
Okay, thank you.
Thank you.
All right. There, hold on, did you cross appeal?
Yes. I have a minute of rebuttal, Your Honor.
All right.
Thank you. With respect to P&K, I want to bring to the court's attention that the P&K contract with Steel Construction says, with respect to P&K, all work should be done under the direction of the contractor, meaning at P&K. That's in the record at page 67. During the course of the EBT of Amber Singh of Steel Construction, she testified that P&K had authority to direct the manner of Steel's work. That's in the record at 1263. And if we go back to the issue that I know the court has addressed, but I want to bring to the court's attention of the issue of TDX, in my reply brief at page 12, I cite a Court of Appeals case, Westmoreland Coal Company, that discusses and holds that, like I mentioned before, that a contract you cannot simply cherry pick one sentence and isolate it out of the rest of the contract. You have to read the contract as a whole. And if the court would go to my brief, statement of facts at page 13 and 14, I lay out 12 overarching and mandatory obligations, contractual obligations, and all of these, at a minimum, would raise a question of fact in order to obtain a reversal. Thank you.
Thank you. Panasia Estate versus 21, no, that's a sub. People versus Vicente Reynoso. You may proceed.
Good afternoon, Your Honors. Nathan Brown for Appellant Vicente Reynoso. The SORA court erred in assessing 20 points under Factor 13 in the absence of clear and convincing evidence that any sexual misconduct had occurred. In this court's decision in People v. Vidro, it held that Dox's definition of the stalking infraction as a sex offense is not clear and convincing evidence that sexual misconduct occurred for the purposes of Factor 13. Because the definitions in the guidelines and Dox's disciplinary regulations is not coextensive. So a SORA court is bound to evaluate the defendant's conduct under the definition in the guidelines. That did not...
What's the basis for your objection to then, if we agree with you, to remitting it and letting the court then make an assessment whether any additional points should be assessed based on this same incident for whether it constitutes sexual misconduct? If we accept your argument that it shouldn't have been done the way it was.
We wouldn't necessarily object to that, Your Honor, but we think that there's enough in this record for this court to determine that the conduct at issue here was not, did not rise to that level. if I can be frank, the suggestion that the note at issue here is sexual misconduct is absurd on its face. When you look at the decisions that define the parameters of sexual misconduct under Factor 13, these decisions all involve sexual contact or lewd conduct, which requires an overt sexual act or exposure of the genitals. In the instances in which only comments are involved, the comments are sexually explicit, and even in a couple cases, including this court's affirmance in Ramos.
So you're saying a comment that's romantically explicit but not sexually explicit is not clear and convincing evidence of stalking?
It doesn't have to be
If I
stalking.
say I love you with all my heart feels this. I don't know what to say to you. I love, you know, my heart. I can't express what's in my heart to you. You're saying that that is not sexually motivated stalking, there's no evidence that that couldn't come under clear and convincing?
It could satisfy Dox's definition of stalking,
No,
but
I'm asking you whether it could satisfy the 10-point or the 20 extra points under the statute.
I don't think so, Your Honor. And
It has to be sexual? It has to say, I want to have sex with you?
it doesn't have to say those exact words, but I think that it needs to rise to a higher level than a romantic statement, which even my adversary in their brief suggests that there's a
Does the context matter? The fact that this is in a prison setting, right? I am assuming that this worker knew that he is in jail for a sexually violent crime, and that context plays no role in this analysis?
It certainly plays a role, and I think what's important.
Because I think if I get that note if somebody gets that note from their fellow cafeteria worker, right? Just another citizen who works at the prison, that's one thing. But someone who you are teaching in a class who you know is a convicted sex offender, he gives you this note, this ain't a problem?
I think it's important. What's key here is that we're not saying that the conduct was not inappropriate. It can be inappropriate conduct without rising to the level of sexual misconduct as it has been acknowledged by the courts. It requires
based
far more.
on whose perception? His intent or her perception of how she feels about this note?
Well, I think that's also a good moment to acknowledge that the standard here is clear and convincing evidence. And what we're doing now is interpreting the subtext.
But I'm asking you, should we be considering how the recipient of this note felt about receiving this note and any apprehension that that note would now make this female worker in a prison teaching someone she knows is a sex offender?
The standard at the SOAR hearing is clear and convincing evidence, and a statement that requires us to interpret the subtext of that statement cannot meet the standard of clear and convincing evidence. Equivocal statements are not clear and convincing evidence.
How is it equivocal when a male inmate who has been convicted of a sexual assault approaches someone he has otherwise no contact and no context with and hands her a note expressing how he can't, after he's told not to do it, he can't express the feeling in his heart? How could that not be clear and convincing evidence of stalking?
Correct, stalking.
If you're told, right, that's what we're talking about here, stalking. Stalking, isn't that?
No, we're talking about sexual misconduct.
Okay, and stalking can be sexual misconduct, correct?
Actually, no, the definition, the reason why this court reached its decision in vitro is because the infraction, the Dox infraction is
Because
framed.
it could be non-sexual stalking, but we're talking about, that's what we're talking about. Whether stalking, sexually motivated stalking is absolutely can be considered.
But I think that it requires an inference on our part to assign that sexual motivation, because what the note says is that I feel something in my heart.
I guess that's what we're trying to get at. Why wouldn't a reasonable person receiving this note, not just this particular woman, I mean, we're not going to have her on the stand to testify, why wouldn't any woman who gets this kind of note in that setting feel that this is of a sexual nature and sexual misconduct as towards her? Why shouldn't a court get to make that determination based on the record, whether clear and convincingly that is enough by itself to show that sexual misconduct has occurred, especially in light of the circumstances where there was a prior note and he was admonished not to do that, and he went ahead and did it?
Again, the conduct was inappropriate, but we are making assumptions on it.
Why is it not sexual misconduct, I guess?
Because we are making interpretations of a statement that, this is sort of a, I don't want to vouch for his poetic ability, but this is a, sort of a poetic statement. I feel something in my heart, that happiness, envy, these are all emotions that come from the heart. I think we're making assumptions about his intent, and that cannot constitute clear and convincing evidence. Maybe he just feels joy. We're assuming that that's not the case, given the underlying offense here. But there's no reason for us to make an assumption that this was sexually motivated.
This is inappropriate. Don't do it. She doesn't feel right about this. And 3 weeks later, he does it, and he adds a little bit more this time.
It was inappropriate conduct, certainly, and there is a.
So you're saying we have to wait until he escalates? We have to wait until he acts on his feelings or says something more explicit in his note?
We have to wait until conduct that rises to the level of sexual misconduct occurs to assign him points for sexual misconduct.
All right. I'll hear from you.
Excuse me. Good afternoon, Your Honors. May it please the Court, Gamaliel Marrero for the respondent. The defendant who raped his 12-year-old stepdaughter while the child's mother was at the hospital giving birth was properly assessed 120 points on the RAI, rendering him a level 3 sex offender. Regarding risk factor 13, 20 points under risk factor 13 was proper because there was sexual misconduct while confined.
Yeah, but the problem with that is that the lower court didn't specifically find that. The lower court found that because it was a DOCSS sort of, wasn't an independent finding from the trial court. So let's assume that the trial court assumed, because it's a Department of Correction definition, that it's automatically correct. Wouldn't the right thing be to send it back to the trial court to make that determination, or if the trial court doesn't decide that, then to see whether or not there's an upward enhancement?
Departure warranted?
Yeah.
Well, not exactly, Your Honor. The guidelines.
I mean, do you think he made a separate finding? Because I read the transcript and I didn't see it.
He says
if you
stalking
think he did,
under
then
docs.
you tell me.
Right, under docs regulations,
Right.
stalking is a sexual offense.
But don't you agree that stalking could also not be a sexual offense, right?
It could be.
And he didn't make any determination one way or the other in this case, right?
In this case, no, Your Honor. He didn't make that specific determination. But this court could also just consider the record here and see that it was a sexual offense here. What separates this from more innocuous behavior, like, for example, if the defendant had just given the first note, Happy New Year, that wouldn't have satisfied the additional 10 points for his risk factor 13. But the fact that he gave the second note after being told not to, which was more direct in his intentions, shows that this wasn't joy or goodwill. It was, at the very least, romantic. Basically, he was hitting on her. In layman's terms, he was hitting on her. He was acting on a sexual impulse, despite being told not to, and that is relevant to his risk of reoffense. But even if this court found that additional 10 points wasn't warranted, there was 10 points properly adjudicated under factor 13 for just general unsatisfactory behavior while confined, because he had 2 tier 3 infractions. Those are the most
Isn't that one of
serious.
the issues in dispute, whether that was appropriate to issue those 10 points?
I'm sorry, Your Honor?
Isn't that one of the issues in dispute, whether it was appropriate to award the 10 points just based on the unsatisfactory conduct, whether it rose to a sufficient level?
Yes,
We didn't ever get a determination from the court below because the court assessed 20 points. So what is your view on whether all of this should be remitted or not for the court below to make a determination whether 20 points should be assessed, whether 10 points should be assessed, whether if none of that is assessed, it should be an upward departure? What's your position on remand?
Well, our position is that remand really wouldn't be necessary here because the record is sufficient to show that the court did not abuse its discretion. Even though the court could have provided more detail and more explanation in his decision, the record that the court relied on is before this court, and it certainly does satisfies the 120-point assessment, but at the very least, it satisfies the 110 assessment, which will still make the defendant a level 3. And also, I would just add that the court certainly has the authority to send it back down for either the point assessment reconsideration or for an upward departure consideration. And I'll note that the people in their pre-hearing written submission did ask for an upward departure to level 3 as an alternative. Unless the court has any other questions, I'm happy to rely on the brief.
Thank you. Counsel, you have 2 minutes on rebuttal.
I won't even take that long. I just want to note that the court, based on this court's case law, is bound to conduct that analysis under the guidelines definition. So it's not that they did enough or that that a remittal would not be necessary. That it is a requirement based on the case law of this court for the SOAR court to have conducted its own analysis. But again, I don't believe the remittal is necessary based on what I said earlier, and then I would just like to emphasize that we don't believe that any points were warranted, and that.
Do you agree with counsel that we could do it ourselves? That we could decide whether or not that extra 10 points was satisfied here?
We do believe that the record is clear that this court could make a decision on it.
And if we decided against your client and the court below denied a downward departure, right? Did you ask for a downward departure?
There was a downward departure. It was
request.
Yeah, he was level 3 on the
So
points.
we wouldn't, that, you're not, so we could make that decision on the 10 points and the rest of the case would be good, correct?
Well, just to emphasize then, our position is not that only the 10 points for the additional 10 points were unwarranted, but it's all points under factor 13 were unwarranted, even more than the misapplication of the points for sexual misconduct. There was no clear and convincing evidence that general misconduct was warranted here. He only had 6 infractions over the course of nearly 20 years in prison, which is not numerous. There was no indication other than the stalking offense what the basis of those infractions were, so they couldn't possibly have been of a serious nature or clear and convincing evidence of a serious nature. And the final criteria is a recent Tier 3. His most recent Tier 3 was 7 years prior to the SORA hearing, so we don't believe that there's a basis for any points under that factor.
Well, let me ask you this. If there was 10 points for the stalking, that would still keep him in 3, even if we took out the 10 points for the other infractions.
That's right, and
Okay.
I mean, we do believe that this court could do that and that he has a due process right to an accurate points assessment. Thank you.
Okay, thank you. VTOL Americas versus Targa Resources. You may proceed.
Your Honors, Eric Leon from Latham and Watkins. With the court's indulgence, my colleague Michael Byrne will be presenting the argument.
No problem.
Thank you. May it please the court. I'm Michael Byrne for Appellant Targa Resources. CPLR 3213 is a limited procedural remedy that is available solely to collect on an instrument that sets forth an unconditional and unequivocal promise to pay money. As Lawrence v. Kennedy makes clear, when the instrument itself expressly makes any payment obligations subject to reserved defenses and counterclaims, the instrument does not set forth an unconditional promise to pay, and CPLR 3213 is inapplicable. And I think looking at the instrument in this case helps to really underscore why the instrument here is not an unconditional promise to pay. So as VTOL notes on page 4 of its brief, the way that this instrument works is that as soon as VTOL believed that Targa Clearview, which is a separate party, owed money to VTOL, it was not required to sue Targa Clearview in Texas. Instead, it could simply have invoked the instrument before any litigation happened and sought payment directly from us. And I think that all parties agree that in that scenario, the instrument's plain language would have entitled us to interpose any number of defenses and counterclaims, the resolution of which would have determined whether we had any obligation to pay, let alone what that obligation was. And that's the very opposite of an unconditional promise to pay. I think that what happened in this case below was that the Supreme Court recognized that the instrument here did reserve to us various defenses, but it concentrated on or thought that those defenses had gotten resolved over time in the Texas litigation.
It doesn't matter if they're resolved, though, because you have to look at the instrument at the time of execution, not at subsequent events. So even if it did totally resolve it, it would be irrelevant. But what is it? So let's say we remand it and they have to have pleadings. Where's this case going to go? Not that that's before us, but where's it going to go? Because if the defenses were rejected, doesn't one follow the other, the guarantee at this point?
Yeah, so they would.
We'll decide the technical issue today that's before us, which is whether you can have a 3213, but what, I'm not really sure what.
Right, what's the
would be
practical
decided.
significance? Yeah, I mean, a couple things, and I think you're right, the only question that's before this court is the technical issue, and I think it does matter for all the other cases that are gonna come before it and leaving appropriate guidance for other courts and other litigants. But I think for us it matters, for a couple of reasons. I mean, one, once you get into the CPLR 3213 lane, it is looked at by the court as though the plaintiff's claims are presumptively meritorious, and there's kind of a bias against normal discovery proceedings or looking into the facts. Whereas,
You're granting summary judgment. That's the answer.
yeah, you're basically moving straight to summary judgment. Whereas we did raise defenses below to some aspects of the payment. The Texas litigation has been going on. There's still parts of it that are going on. That may determine what kind of defenses we would raise if they decide to come back with a complaint, as I assume that they would. But I think that the bottom line is that we just think that
Are
they
you
should.
saying that you have defenses that you didn't raise in Texas?
Well, I think there's two questions, right? One question is right what Targa Clearview raised.
I'm asked, right, so I
Right.
know what, I know what
Yeah.
my question is.
No. So I think the honest answer, Your Honor, is that that's a determination that we have yet to make, that we would make.
So
in
why wouldn't res judicata prevent you from raising anything that you could have raised in Texas in New York?
Well,
Basically, what will happen, I think, is, I mean, the Texas court, the intermediate appellate court has affirmed, right?
Yeah.
And now you're seeking leave?
Right. So there are some proceedings that are ongoing before the Supreme
So
Court.
I assume what would happen is a motion for summary judgment on res judicata grounds, right?
Well, so I understand. So two things. First, there are parts of their demand for money that are somewhat separate from the Texas action, in the sense that, for instance, they sought attorney's fees. We argued below that that they weren't entitled to those attorney's fees. We would continue to make that argument. With respect to res judicata, totally understand Your Honor's question. I think they probably would make that argument, and we'd have to evaluate at that point in time whether we had defenses that would.
Bottom line is this is not the right way to do it, because no matter what effect it has, it's not your argument is that it's not a proper 3213.
That's right. And at the end of the day, they're entitled to file their complaint, and these issues can be raised and addressed then. I'll reserve the remainder of my time. Thank you.
Thank you. You had 5 seconds left, so perfect.
May it please the court, Your Honor, Melvin Brosterman, formerly with Strook and Levan when we filed the papers, presently with Hogan Levels.
Let me ask you a question. Well, sorry you had moved, but
yeah,
yeah, me too.
Sorry, Strook's not.
Yeah.
But anyway, let me ask you the counterpoint of that question. Why not just move ahead and serve a complaint and let them answer, move for summary judgment on the fact that it's res judicata, which is not what we would do in this proceeding?
If I may, Your Honor, counsel has the facts wrong and the law. Completely wrong. Let me just tell you why. Let's start with the law, okay? The law is...
Well, then let me interrupt for a second.
I'll answer your question.
The law under Karen is that whether or not a guarantee is, can be an instrument for the payment of money only, you have to look at how the instrument presented when it was executed, not at subsequent.
Correct.
So why don't you
I'll address
for
that.
me that specific
Got
question?
it.
At the time of execution, how was this sufficiently an instrument for the payment of money?
Okay, if you have a note or an unconditional guarantee, and this guarantee says irrevocable, absolute, and unconditional, right?
But it's different than, I have never seen a guarantee like this, to be honest. All the guarantees I see normally are instruments for the payment amount only because they are unconditional. But this has language that I haven't personally really seen before, despite doing hundreds of guarantee cases, which incorporates defenses. And I don't understand why that would take it out of the
Got it.
3213.
Let's assume it didn't incorporate. What it is it limits the defenses, if you think about it. Let's assume.
Absolutely not. A guarantee normally says unconditional, I'm not going to raise anything. I waive every single right, including presentment and all the rest. So this is not your regular guarantee, right?
In this court, in SCP Bermuda versus Bermuda Tel, okay, it also did the same thing in Allied Irish Banks. It's this court. What happens is the court found that plaintiff established a prima facie case based on a note and guarantee under 3213, even though the guarantors explicitly retained certain defenses of gross negligence and willful misconduct. Here, they have retained certain defenses, namely
No, but
those.
this says they reserved all rights, counterclaims, and other defenses. They reserved
no.
everything.
Available to the obligor, okay?
So they're basically in the same position as the obligor. That this is not a guarantee case. Like this would be you suing the obligor and arguing it's an instrument for the
Judge, okay, there is no law that says, not this court, not the Court of Appeals, not the Second Department, there is no case that says that a guarantee or a note, let's deal with a note, is you can only move under 3213 if it includes a waiver of all defenses. There is no such case.
No, but you have to look whether it's unconditional.
Okay, well, if it says on its face it's unconditional, even if it reserves to the defendant certain defenses, according to SC.
How are those two things compatible, right?
Because one is. Okay.
You can't say, I give you an unconditional guarantee.
They're
subject to these defenses.
Because, no, it's not subject to the defenses. Because Bermuda Tel says, if I have an unconditional guarantee, and this says it's unconditional, I put the guarantee into evidence, I make my
counsel,
motion.
let me just interrupt you for a second. Sure, that case is, and Century City Mall versus Waxman says if it's not an unconditional guarantee, it's not a 3213 motion. So I'm sorry, the fact that there's one case that you think fits in your scenario, let's assume let's assume that we don't agree.
Right.
Let's assume that we don't agree that this is an unconditional guarantee. Right? Let's assume that we don't agree that in this complex commercial transaction that you can do 3213. What do you say as to you've got to go back down and do a summons and complaint? What is the damage to you? What is the damage to you for
Other
having
than the
to
fact
do that?
the damage to us is other than the fact that it took as long as it's taken to get here. Also, okay, the court below found, under Bermuda Tel, under Allied Irish Bank, under all of the cases of this court, the court said, once, I put in the unconditional guarantee, whether it's a note or a guarantee, once I put that in, they have the burden of putting a defense. They put none in, zero, not a single affidavit.
But it's not an unconditional guarantee.
It is when never confuse an unconditional guarantee, with a reservation of defenses.
We're not confusing that.
No, but I
Believe
don't have
me,
to-
counsel, I'm not
understand.
confusing
The
that.
point is, the cases say, I don't have to prove the absence of defenses to prevail on a note
Absolutely.
or a guarantee.
You do have to prove that it's worthy of 3213.
All I have to prove is that I have an unconditional guarantee that the money is owed, and I have a judgment, so I know the money is owed, under the judgment, and then under 3213, even if it didn't have this provision in it, let's assume it was silent, as many guarantees are, and there's 3213 motions made on notes and guarantees every day of the week that say nothing about defenses, The motion is made, the burden is then on the defendant to interpose an issue of fact. And the fact that those notes don't contain waivers of defenses or the guarantees don't contain waivers of defenses does not make those any less unconditional, because from the plaintiff's perspective, what I have to do is I have to show that there's a note, that the note wasn't paid. I have to show there was a guarantee that the obligation wasn't paid. That is all I have
That's
to do.
you, under 3213, that's all you think you have to do?
Your Honor, okay, according to...
Without, I mean, you don't, all you have to do in the face of a defense that this is not an unconditional guarantee?
If they... Reservation of defenses does not make it an unconditional guarantee.
All right.
The Lawrence case, if I may,
Thank
the
you.
Lawrence case is...
We're out of
particularly
time. Thank you. You have 2 minutes.
I just have a couple of things to say, and I'll be very brief. The first thing is that counsel's trying to rely on situations in which a guarantee is silent with respect to whether, defenses are waived or reserved. That's entirely different than a situation in which intrinsic to the guarantee itself, the guarantee is reserving the right to make defenses. That's what makes it makes it not an unconditional guarantee, and that's what Lawrence says. Ours is the same as that. Counsel complained that the prejudice that they'll suffer if this court reverses here is that, they've spent a lot of time doing this, but that's prejudice of their own making. They should have filed a complaint. If they had done that, they wouldn't have had to spend this time. We wouldn't have had to spend this time litigating this issue up to this court. Finally, I'd like to address, actually, two final points. Counsel wanted to rely on the SCP Bermuda case. That case is totally an opposite to this, and the reason why is that what this court relied on there is that the instrument there, the two parties agreed and provided in the writing that the instrument there was a instrument for the payment of money only and could be enforced through a CPLR 3213 motion. And so you had there the parties agreeing that it was an instrument that was for an unconditional guarantee for money. And the last thing I'll just say is that although counsel keeps insisting that this was an unconditional guarantee, I will point out that at page 94 of the record, their own senior vice president and general counsel below submitted an affidavit describing the guarantee here as a conditional unlimited guarantee. So again, we think that the right result here is to remand, and then they're entitled to do whatever they want to do next.
Thank you so much.
Nice job.